has been broken only momentarily, but the issue is before the Senate and the Congress. The constitutional issue of filling the vacancy caused by the resignation of former Vice President Agnew will be before the Senate shortly when the President sends up a nomination. (180) Congressional Record. Mr. President, every session of Congress always ends with much work left undone and many jobs unfinished. That is in the nature of things and is not likely to change. But there are some tasks that cannot be delayed, and there are some times that cry for change. One of those tasks is the reform of the election process to correct the abuses rooted in money and secrecy. Congress must not go home without taking notice of the public outcry against failures of government and without changing the patterns of the past. No problem facing our nation today is greater than that of the steady decrease of confidence in our political system and in ourselves. This results from much evidence that our present campaign system corrupts our principles, our leaders, and ourselves. Reform of that system is essential so that we can restore confidence and self-respect, and this is necessary so that we can take care of the other problems we face. We all take the oath to support and defend the Constitution. Our procedures have been under attack for the past few years. The spirit and intent of the law has been abused, and in some instances the letter of the law has been violated. Now, this is particularly so in our campaign and election systems. Members of Congress must feel the weight of their responsibility for reform that bears not only upon the national legislature, but upon each member individually as elected representatives and as practicing politicians. If the Congress cannot now provide an answer to election reform, there are, nonetheless, many personal solutions that can be taken. In 1973, the Senate passed a Campaign Reform Act. That bill had been passed, and it was an improvement in federal election campaigns. Yet that bill now lies in a House subcommittee. It is dead for the 1974 campaign. Its promises are empty. In 1973, the Senate talked about public financing of campaigns. A majority of senators agreed that this step was necessary and proper to make our system one in which we can all once again take pride. Yet public financing was talked to death on this floor. And while we have the firm promise of committee action within the Senate on public financing bills next year, we know such action cannot affect 1974 campaigns. In 1974, we can accomplish much. In 1974, the Congress can enact public financing. In 1974, Congress can enact legislation to set ceilings on contributions and campaign spending. In 1974, the President can join with the Congress and the courts in seeking to ensure that the abuses of the past are accounted for and that our campaign system is such that these things cannot reoccur. We must do all of this even if we realize that the laws now in effect will still be in effect in 1974. And so we contemplate that what more we are able to do now. Laws, as a general proposition, measure the outer areas of human behavior that are prohibited by society. Laws leave us freedom to choose the level of social attitudes that we will exhibit toward our fellow men. Thus, the law prohibits crime, but leaves us free to determine whether we will in fact live in love and charity with our neighbors. Thus, the law exacts through taxes a minimum contribution for public welfare and defense, but leaves us free to volunteer personal work and gifts for the causes we think are also important to the community. Why should we not consider that election laws be seen in the same light? These are not the rules I have lived by in the past. They are different from the rules followed in 1960 when I was first elected to the Congress. They are different from 1968 when I was first elected to the Senate. Indeed, they are different from last May when many members of the Senate honored me by their presence in Baltimore at a fundraising dinner from which a balance remains. Perhaps we all should have been wiser in years past, but we cannot turn back the clock and start reform in 1960 or 1968 or even 7 months ago. What we can do is start now. In seeking this new start and this new direction, it is necessary to make a goal clear. And that goal is not some high degree of personal virtue. After all, it is our ancient prayer that the Lord should not weight our merits, but pardon our offenses. What I am seeking is rather a new system, a new method, a new standard which will make our government more truly democratic. And none of the steps I have listed are presently required by federal law. Some of them go far beyond any proposals which we have debated and supported. But in each case, those who have recommended such steps have been told that no candidate could run a good campaign if he abided by such rules. In each case, I have argued to the contrary, and so today I pledge to test out my own beliefs. I am confident that the people of Maryland can demonstrate to the Congress that campaign reform can work. It is the road I feel I should take. Okay, tell me yours. Mr. Thompson. No, I'm sorry, you're Mr. Tunison.
Okay, for the defense, I'm Mr. Tunison, T-U-N-I-S-O-N.
And the court,
I am the witness.
for the people, Mr. Thompson, T-H-O-M-P-S-O-N.
Okay, it starts with question by Mr. Thompson.
Do you recall whether the light was on at the time?
Yes, it was on.
What about the area marked JA-JP70? Was the light on that pole?
Yes.
Did you observe Mr. Crawford's demeanor as he came across the lawn area at you carrying this object?
I don't understand what you mean.
Well, by that, was he calm or mad or angry?
Well, insane is the word for it.
And as you were struggling for the axe, how would you describe his demeanor at that time?
Well, he was just trying to get the axe.
Did he make any statements to you during the struggle for the axe?
No.
What happened then, Mr. Dawson?
Well, after I hit him with the bottle, we still were wrestling for the axe, and he grabbed me by the hair. It was all in my face. I couldn't really see. Bobby Lawford come over. She was screaming to give her the axe. At some point between, I kicked Mr. Crawford in the groin, and I gave Mrs. Lawford the axe after. You know, I really made sure. I will give it to you if you take it. I was really yelling.
I am having a little difficulty in putting it all together. Now, you left out 3 times. You hit him with the bottle. I don't know that came before or after this.
I thought he went already over there.
I know, but I don't know where it fits in.
I was hit with the axe, reached down and grabbed it by the handle. We danced around for a couple of seconds. I hit him once and it didn't bring him down. I hit him again and it didn't bring him down. I hit him again and the bottle broke. Then we moved it this way. Then he grabbed me by the hair and I kicked him then in the groin. Mrs. Lawford, some car pulled up. People were in it. There were people in the car, and the people in the car yelled something to him, or so I thought the guy said, "Crawford, you are a fool." Now that is the way I can remember. And then Mr. Crawford started yelling something to him. Before that happened, Mrs. Lawford said, "Give me the axe, give me the axe." I said, "I will give it to you if you take it," because I didn't know what she was going to do with it. So I kind of shoved it to her. At the same time, Mr. Crawford let go. At the same time, Mr. Gatsby, who was in the car, it turned out, came out, and he came and got the axe.
Did you recognize any of the other individuals that were in the car that drove up?
After he got out, I recognized Mary Castle.
Anybody else?
Mr. Gatsby.
Regarding the statements that were made by Mr. Crawford to the occupants of the car, do you recall at the present time what those were?
Just, "You can't fire me, you can't fire me." Pretty obscene.
When you say pretty obscene, do you recall what words he used?
Do you want me to use the exact words?
Yes.
Sure do.
He was saying, fuck you, you can't fire me, fuck you."
Now, when you say you struck Mr. Crawford once with a bottle and it didn't break, and then the second time, and then the third time it broke when you were using the bottle, were you just trying to break the bottle or trying to strike him so that he would let go of the axe?
I was trying to knock him out, you know.
Was the third blow that you used the strongest blow of the 3?
I don't think it was any stronger than any other ones, but it must have been.
Incidentally, Mr. Dawson, did you see Mrs. Roberta Lawford in court here today?
Yes,
Was she the blonde-headed lady that was seated next to Mr. Crawford in the courtroom?
right.
After the axe was taken by Mrs. Lawford, did you see where it was taken? Did you see where it was put?
Well, right after he got it, Mr. Gatsby got it.
Did you see what he did with it?
No.
Did you get a look at the axe?
Yes, I got a look at it right after, right before I grabbed it.
Could you describe generally what type of axe it was?
It just looked like an old rusty double-bladed axe.
Would you describe what clothing you had on at that time?
I had a brown leather jacket, a green t-shirt, some blue jeans, some shorts, and a black leather belt.
Your Honor, I have a long cardboard box which previously has been marked for identification as People's One. You had an opportunity to examine this, is that right, Mr. Tunison?
Yes, I have.
From the box, in the presence of a clerk, I have extracted certain objects, and I will hand the witness one marked People's 1A for identification. Could you tell us what that is?
My brown leather coat.
Did you have that on at the time you were struck with the axe?
Yes, I did.
Prior to the assault on your person and directing your attention to the cut area in the back of the jacket, was that there?
No, it wasn't.
I will offer that in evidence as People's 1 and 1A, Your Honor.
Be received in evidence.
Showing you People's 1B for identification, a pair of denims with what appear to be brown stains on the rear portion thereof. Are those the pants that you had on that date?
Yes, they are.
I will offer these in evidence as People's 1B, Your Honor. For the record, they also contain a slight rip at the top of the pant toward the rear. Was that there prior to your assault?
No.
Was the brown stain there prior to the assault?
No.
Be received in evidence as People's 1B.
Showing you People's 1C, are these the undershorts that you had on that day?
Yes, sir.
And directing your attention again to a torn portion on the back surrounded by reddish-brown stain. Was that there prior to your being struck?
No, it wasn't.
I will offer that as 1C, Your Honor.
Be received as 1C in evidence.
Showing you People's 1D, is that the shirt that you had on that occasion?
Yes.
Directing your attention to the torn portion in the back lower part surrounded by reddish-brown stain. Was that there prior to your assault?
No, it wasn't.
Be received as 1D.
Were you taken to the hospital by Officer Manson of the Fairmont Police Department?
Yes, sir.
And did you still have this clothing on your person at that time?
Right.
And did your brother Timothy accompany you to the hospital?
Not personally, not in the police car.
Prior to Mr. Crawford coming at you with what later turned out to be an axe, did you at any time go on the Lawford property?
No.
All right. I don't believe I have any further questions, Your Honor.
All right.
Mr. Dawson, approximately how long was it that you had known Mr. Crawford was before this incident occurred?
I am not sure. I am not sure when he was appointed city administrator, but roughly, I guess, I would say a year.
About a year before the incident?
I think so. I am not sure.
Would you say that you are active in Fairmont city politics?
I object to that as being ambiguous and unintelligible and also somewhat irrelevant.
It may be preliminary. I will allow it.
Thank you.
I don't see how the witness can answer a question like that as to whether or not he is active. What is meant by active? I think we ought to go into some specifics.
You can cover it.
I am not active in city politics, but let me give you an example. I saw a scene where the Fairmont City Police, in my eyes, were using excessive force, and I went down and made a complaint about it. If there is something on my mind, I won't keep quiet about it. Put it that way.
All right. Now, so if you have disagreements and objections with things that are going on in the city, would you say that you make these things known
Not within the city, more just within the police force.
within the police force? Okay. Did you have some objections to the Robert Crawford was conducting his office?
I had no knowledge of the way he was conducting his office.
Did you have some dislike for Mr. Crawford before this incident?
Yes, I did.
On what was that based?
Well, it was based on the...
I object to that as being irrelevant. Once the witness has indicated he does have a dislike for an individual that he is testifying against or party to an action, the reasons for the dislike are irrelevant and immaterial.
Your Honor, I would say to the extent of the nature of the sort of dislike that is concerned is all extremely relevant.
I don't believe it is, Your Honor, because once the fact of bias or dislike is admitted, that is the only fact that is relevant, and the reasons for the dislike are completely irrelevant. I think that is very clear that the only relevant fact is the existence of any dislike, which the witness candidly and truthfully admitted.
I don't think I can foreclose it completely, Mr. Thompson, by asking the witness on direct examination whether he disliked the person, because I think we all dislike a lot of persons. But as the basis of that dislike, like we think the dead person murdered our mother and father, that puts a different complexion than just a statement, I just dislike him.
I don't believe so, Your Honor, because the material fact is whether or not the witness dislikes another individual against whom he is testifying. Now, the extent of that, whether it is slight, intense, or hatred, certainly that can be inquired into, but the reasons for the dislike, I think it has been held time and time again, are completely irrelevant.
I think you are correct. If the reasons in and of themselves are irrelevant, but certainly the degree of dislike can be approached.
That wasn't his question. He asked, what do you base that on? If he wants to explore the degree of dislike or intensity, I have no objection.
All right.
Let me approach it this way, or his way, Mr. Dawson. Had you ever made your dislike known before the night of this incident
To whom?
Anyone?
to anyone?
Probably to my friends.
How about to Mr. Crawford?
No, I don't think so.
Do you have some doubt about that?
Well, the only thing that I have ever even encountered with Mr. Crawford before this was he was coming across our street. He came across the bridge. I was talking to a friend explaining to him some things about his car, and Mr. Crawford seemed to get fairly upset because we didn't move around and let him by right away, and he seemed, well, he pulled out a pad and pencil like to write down my license plate, something to that effect.
How long did that incident last?
15 seconds?
Had you ever addressed any remarks to Mr. Crawford before?
No.
Had you ever mocked him or called at him?
No.
Had you ever seen him on the street?
Never on the street. I have seen him in his car.
Did you ever call out to him while he was in his car?
No.
Now, concerning the party, let me back up just a minute. Concerning the party, you said you had some champagne to drink. Is that correct?
That is correct.
Were you also dispensing champagne to other people?
Yes, I was serving drinks.
And while you were serving drinks, you were also drinking drinks. Is that right?
No.
No? That was separate from the time you were drinking drinks?
Well, what I did was I opened a bottle and I poured drinks to everybody around me and poured myself a drink and put the bottle down.
Was that just once that you served people?
Well, I was in the kitchen most of the time, and most of the people around me were the same people all the time.
Did you serve them several drinks?
Yes.
And each time you served a drink, you also had a drink?
No, it depended upon the bottle. The bottle ran out most of the times before I could get a drink.
Was there a lot of discussion of Mr. Crawford at that party at that time?
Well, most of the discussion I heard was about the 49ers.
This party was held just after the election in Fairmont, was it not?
Yes, it was.
And it was held at Mr. Easom's house, this party?
That is right.
And Mr. Easom had been successful in this election, had he not?
Defense Attorney, Ms. M-I-S-S, Newkirk, N-E-W-K-I-R-K.
In the court.
I'm the witness.
I am for plaintiff, Mr. Taylor, T-A-Y-L-O-R.
Okay, and we're starting off with the court at the top.
People versus George Fuller. Is George Fuller your true name?
May I have a moment, Your Honor?
Yes. Does the defendant waive further reading of the complaint and statement of rights?
Yes, Your Honor.
You may be seated. Call your first witness, please.
People call Officer Saunders.
Please raise your right hand. You do solemnly swear the testimony you are about to give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Your name?
William D. Saunders, S-A-U-N-D-E-R-S.
Thank you.
Motion to exclude the other witnesses.
With the exception of the investigating officer, all other witnesses intending to testify in the George Fuller case, please wait out in the hallway.
I make a motion to exclude the investigating officer as he may be called as a witness, and I believe he is precipient to the events.
The court has discretion and I have ruled.
Thank you, Your Honor.
Officer Saunders, what is your occupation and assignment?
Police officer for the city of Los Angeles, currently assigned to Wilshire Narcotics.
Were you so assigned on May 28, 1975?
Yes, sir.
On that date, did you proceed to the location at 200 North Harvard Boulevard in the county of Los Angeles?
Yes, I did.
And approximately what time was that?
It was at approximately 7:45 p.m. that we went to that location.
Why did you proceed to that location?
I received information along with my partner, Officer Crum, that two male blacks, one called Mason and one called Fuller, were dealing heroin from that location.
Objection, hearsay.
The hearsay will be sustained, but the statements will remain in the record for the fact of the contents, not for the proof thereof. Proceed.
The information was received from a confidential, reliable informant, and the additional informant concerned the physical size of the persons dealing of the heroin. Mason was described as being approximately 5'8", 145 pounds, and Fuller was described as being 6'3", and approximately 210 pounds.
When you proceeded to that location, was it a single-family dwelling or apartment building?
It was a multi-story, multi-unit apartment building.
Did you proceed to any particular apartment?
Yes.
Do you know the number?
We went to the apartment number 213.
And when you proceeded to apartment number 213, what did you do?
I knocked on the door, and after approximately a minute, a male voice from within asked who was there, and I stated, "Police officer, we are here to conduct a narcotics investigation." And I asked to speak to Mason.
Then what happened?
A few moments later, the person apparently walked away and came back and opened the door.
Objection, conclusion.
Sustained.
Motion to strike.
Granted.
After you identified yourself, what happened?
Approximately 1 minute elapsed, and then the door was opened.
Did you observe anybody at the door?
Yes.
Who was that person?
The person at the door was the defendant, Mr. Fuller.
Did you have a conversation at that time with the defendant?
Yes.
What was that conversation?
I displayed my badge and stated, "Police officer, here to conduct a narcotics investigation." And again, I asked for Mason.
Then what happened?
Just about the time the male was going to ask us in, another male approached the door.
Motion to strike the testimony that the male was going to ask him in. That is conclusionary.
Well, unless that is based on some facts in the present framework, the motion is granted.
Thank you.
You say another male approached the door?
Another male approached the door, and that male was wearing a towel wrapped around his waist, which said, and then he said, "I am Mason."
Then what did you do?
Again, I identified myself and stated, "Police officer, here to conduct a narcotics investigation."
Your Honor, there would be a motion to strike based on the other person stating that he was Mason as hearsay.
That hearsay objection would be sustained, however, the statement will remain in the record for the fact of the statement, rather than proving the truth of the contents thereof.
Thank you.
Then what did you do, officer?
Well, the male that identified himself as Mason invited myself and my partners, Officer Brown and May, into the apartment.
Objection, conclusion.
What is the conclusion, ma'am?
Well, the officer is stating,
I can hear you much better if you are standing.
the officer is stating that he was invited into the apartment, and that is conclusionary. He is not testifying as to the facts.
What, if anything, did the person say? The objection will be sustained.
Your Honor, he stated, "Come in."
Let's proceed.
Thank you. Well, once we were inside the apartment, the male that identified himself as Mason also stated, "What is the problem this time?" and pointed to Officer Brown and said, "You were here before. What did the complaint say this time?"
Objection, hearsay.
Objection overruled.
Then what happened?
The information was relayed to him that we had received a narcotics complaint. The male,
Mr. Saunders, will get along much better if you won't give conclusionary answers. You are asked for conversations. If someone said something, you may react as a tape recording and reflect what they said. Read the last question. That will be stricken and you may answer the question now. What happened next?
it was at that point that I told Mr. Mason about the information that I had received, and I relayed it to the court earlier.
That will be stricken.
Thank you, Your Honor.
Exactly what did you say?
I stated that an informant had called the Wilshire Narcotics Office, and the informant told us that Mr. Mason and Mr. Fuller were dealing heroin from that apartment, 200 North Harvard apartment number 213. It was at that point in time that Mr. Mason stated, "The apartment is in my name. Go ahead and look around if you think there is any heroin here."
May I approach the witness, Your Honor?
For what purpose?
I would like to see what he is referring.
Well, for the court's information, I am referring to the official report, my copy, concerning the arrest of the defendant, Mr. Fuller. This gives me a verbatim.
Let me ask you this, sir. Do you have a precise memory as to all the exact details?
I could give you the general facts.
Officer Saunders, we'll get along much quicker if you listen to the question and respond exactly. Do you have a precise recollection of all the details, yes or no?
Yes.
Then you do not. I am going to explain, officer. If you need the report to refresh your recollection, you may use it, but a foundation must be laid. The question is, do you have a precise recollection of all the details?
No, Your Honor.
Do you need the report to refresh your recollection?
Yes.
You may use it.
Thank you.
Go ahead.
For the record, is this a copy of the arrest report?
Yes, it is. Do you have a copy of that?
Yes, but I wanted to ascertain that was what he was looking at.
The witness has testified under oath that is what he wrote.
Thank you.
You testified that Mr. Mason said, "Come on in and look around."
That is correct.
At that time, was the defendant Fuller present?
Yes, he was present at that time.
Did he make any statements at that time?
He did not.
Did you proceed to conduct an investigation?
Yes, I did.
And where did you go and what did you find?
I went to the rear of the apartment and I started checking the bedroom located in the northeast portion of that apartment. In that bedroom, I checked it through the closet and I found located in the left front pocket of a suit coat 2 hand-rolled balloons that I later found to contain a tannish powdery substance. I also found in the right front coat pocket of this same coat empty balloons. In that same room, I found an envelope and a piece of paper addressed to the defendant, Mr. Fuller, at that address, 200 North Harvard, apartment 213.
Officer, what did you do with the balloons containing the tannish substance?
I placed the balloons in my right front jacket pocket and later took them to the Wilshire station and conducted a narcoban test on the substance that was in the balloons that were hand-rolled.
After conducting the narcoban test, then what did you do?
I placed them into a small envelope and I then sealed them in a larger LAPD analyzed evidence envelope and booked them in at Parker Center Property Division.
Your Honor, I have a sealed analyzed evidence envelope, DR number 75536-050. May it and its contents be marked as People's One for identification?
So marked.
Officer Saunders, is this the envelope that you placed the balloon containing a